And here we go.
Good evening, our Patriot family, and welcome to another episode of the Fight for Patriotism, where we discuss the Constitution and how it will help us get our country back. On tonight's episode, we will be discussing the Third and Fourth Amendments. I'm your producer, host, and Patriot brother Zachary Smouse, and with me is your brother Angry Conservative. I'll say the Bible verse of the day, play my introduction, and check on how our brother is doing. The Bible verse of Thursday, July 21st, 2022 is, "For it is God who works in you to will and to act in order to fulfill his good purpose." Philippians 2:13 NIV.
We need you now. We need you now. One day, one day, one day, I hope you see the truth. This puppet show stays on because of you. We've been dancing with the devil way too long. I know it's fun, but get ready to pay your dues. Oh God, come back home. This crazy world is filled with liars and abusers. We need you now before we're too far gone. I hope one day they finally see the truth. God, we need you now.
How are you doing this evening, brother?
I am doing good, and the last one that just put the thing in the real Greg Kelly, that brother is my friend. He came over from my channel because because I've been helping you out a little bit at a time, and so he's a good guy. He is an Army vet, so. And hello to everybody out there. I hope you're having a wonderful night. And me and Zach are going to go back and actually teach a little bit about our rights under the Constitution. Hello, yeah, I got a few more likes. And Deborah is one of mine. Hey, Deborah. So you're getting a few more. Not many. I don't have as many as you do. But I am getting some to come over and. So, Zach, how in the heck are you doing, my friend? But yeah, you might actually see there might be a couple more pop in at some point. I don't know. Ugh. But Zach, hey Cindy, I hope you're having a wonderful night. Yes, smash that like button for this brother. I miss Nick and Miss Taylor, Mr. Tom. Mr. Ghetto, I hope you're having a wonderful day. Cindy, I think it's hot everywhere. Just saying. How does everyone like my background? I think it's appropriate for what we're actually doing. Hey, I think it's the best background I can have for doing the Constitution. Yeah. Ugh. I'm sorry, Zach, but I am a little bit tired. But hey, Unchained, I hope you're behaving yourself.
I'm
Don't
good, brother. By the way, hey family, I'm not asking for donations, but I just want to let you know that the donations that I receive, I'll split the money with my panel, and every donation I get, I'll put towards prepping items.
So if you can help the brother out, I don't care if he gives me any money. I'm not worried about it. Help this brother out because he is doing a lot of great content. He is doing a lot of putting out a lot of great information, and that's why I care about the brother. Zach, what do you think? Are we going to get this country back? With what we're teaching, are we bringing, and I want to ask this chat this, are we bringing you guys together with this information about what our rights actually are? Oh. Hey, Zach, this is the question I have.
What the fuck is the matter with people?
Hey, Mayor. Zach, I'm surprised you didn't do something when you seen that.
Ghetto, you hope.
Hey, Brookie. Yeah, and Diana, that wasn't Zach. That was actually me. And Zach, say it again. We might be teaching about some things, but we do want to have a little bit of fun with it.
Ghetto, you little whore, you.
Uh, oh, for crying out loud! I think we've created a monster with you, Zach. HAH. But and Brooke is from my channel. But yes, I have a lot of my day ones are coming over for you, Zach. So they are good people. I will say that right now. Zach, can I ask you to do me a favor? Because I know it's already programmed on to your keyboard. Will you let my people know about you?
My name is ▲ᖃᘿᘍᑍ. I'm 29 years old and I have cerebral palsy. I have had CP all my life. I was diagnosed as a baby. The reason why I got my unique ability was because there were complications at birth. My umbilical cord was wrapped around my neck 3 times and my birth doctor didn't wait until my birth mother was dilated all the way. Because of that, I came out not breathing. Long story short, I was pronounced dead for 27 minutes. Honestly, I prefer my unique ability because it gives me a different perspective on life that others might not understand. Like there's evil in this world and stuff, but I try my best to be here for people who need someone to talk to. I just believe that in the 27 minutes that I was dead, I believe that God took away my ability to walk and talk normally, then replaced it with a brain and heart to help others no matter what they need. Life has been good with having a unique ability. Sure, there's some asshats that think I shouldn't be speaking my mind and being open to others. But I don't really care because I am who I am and I don't need people who are negative in my life. Some of the challenges that I have faced with dealing with my unique ability are making some people realize that other people matter. It doesn't matter what the outer physical appearance looks like, it's what the inside that counts. I just believe that there's some people who need to come to realization that they aren't the only ones who matter. Honestly, the other things that has happened to me isn't really petty, but I just want people to realize that we just need to come together and be here for one another no matter what happens.
And check your Cash App there, Mr. Smouse. And to the ones that I brought over, that's why I love this man. That's why I call him my brother. He is an outstanding man, and I love that me and him get to do this together, and that's why I asked him to share, because most people on here already knew that. A few people didn't. But, Zach, good job.
Thank you BB72 for the donation.
And Zach, Miss Nick, as you can tell, you got friends now from. So that's you're a part of my little group. So even if you don't like it, you little rascal. Yes, I had to use Tom's words. All right. Now, let's get down to business why we're actually here. Let's get to that Third Amendment. I am going to start. Zach will start pulling up the video. The Third Amendment. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. So in other words, soldiers cannot be housed in your residence if you don't want them there. Just saying.
Hey, this is Kim from Khan Academy, and today I'm talking with some experts about the Fourth Amendment. This is the Fourth Amendment of the Bill of Rights. Hi, this is Kim from Khan Academy, and today I'm learning more about the Third Amendment to the U.S. Constitution, which states that no soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. This amendment clearly draws its inspiration from the Quartering Acts that caused a great deal of tension between the American colonies and Great Britain leading up to the American Revolution. But does it have any relevance to our lives today? To learn more, I sought out the help of two experts. ‎ is a professor of law at Boston University School of Law, specializing in constitutional law and the Supreme Court. Glenn Reynolds is the Beauchamp Brogan Distinguished Professor of Law at the University of Tennessee College of Law. So, Professor Reynolds, why did the framers feel it was necessary to put this amendment in the Bill of Rights?
Well, we don't think of quartering of troops in people's homes as a very big issue these days. And of course, some people would say that's because the Third Amendment's worked perfectly. If only the rest of the Bill of Rights worked so well. But it was a big issue for the framers because it had happened a lot. To the framers, the English civil wars of the 17th century were recent history, and their attitudes were very much shaped by that. And the Stuart kings in particular used quartering of troops as a way to punish towns and areas that they didn't like. The soldiers back then were basically jail sweepings. They had a tendency to steal and to rape and to get into fights, even with the people they were quartered with. So it was to have troops quartered upon a town was a way of sort of mass punishment. And that made the English rather unhappy. And after the Glorious Revolution, they banned the practice in England, but they did not ban it in the colony.
The king had quartered troops in private homes in the colonies in what became the United States for a long time before the Revolution, since at least 1670. And as it's easy to imagine, this caused a lot of tension between the homeowners in the colonies and the British troops. And then it got even worse as we found ourselves in the French and Indian War in the 1750s and 1760s. Because nobody wants the government to put troops in their house. The house is the place where people live their most private lives, and to have the government come in and say, here, the soldiers are going to live here with you now, is something that understandably the colonists were very worried about and didn't like very much. So things got worse in the 1760s when England passed the first Quartering Act, which basically required the colonies had to provide barracks for the king's troops. And if there weren't barracks, then the soldiers were authorized to live in inns and ale houses and houses, this is right from the act itself, selling rum and brandy and strong water. And then if there weren't enough of those around, they could live in private buildings, uninhabited houses and barns and things like this. And that requirement resulted in part in the Stamp Act of 1765, which led then to the Tea Party, which everybody knows about. And the Tea Party really made the king angry. After that, the king passed, or the parliament passed, the Second Quartering Act of 1774, which required colonists to allow the king's troops to live in their homes, which was, of course, something that the colonists absolutely couldn't stand. So when we got our independence, it was one of the most important goals of the framers to make sure that this kind of thing could not happen.
So what was so problematic about the possibility of having a soldier quartered in your home, or multiple soldiers quartered in your home?
Well, some of us don't particularly like having house guests in general, but they're not house guests. I mean, the problem is, troops back then were not like we think of soldiers today in the American Army. It's hard to get into the Army. People try to get in the Army and they're told, go away, your grades aren't good enough and you're not smart enough. And if you have a criminal record, they don't want you. It wasn't like that back then. Warfare was bloody and awful. The troops stood in masses of 100 yards from each other and blasted away with these brown vest muskets. Actually, the most common injury then was when pieces of the soldier next to you were driven into you, jawbone and stuff like that. So it was pretty nasty, and the discipline that it took to make people do that was pretty harsh, and it wasn't very appealing to the better sort. So literally, a lot of these soldiers were people who were sent there straight from jail. So they were not very nice people to have living in your house, and they didn't have a very good attitude when they did.
I think they were widely viewed as being cruel, as being unfriendly, maybe even drunk a lot. But it was certainly not the case that they were making their own beds and cleaning up after their dinner and such like that. So it was they were not guests. They were people who were living in the houses, taking liberties any way they wanted, and making basically a nuisance of themselves for sure. So, I mean, imagine if some soldier you didn't know and you didn't invite into your house was all of a sudden staying in your living room, and then multiply that by however many soldiers it might be, 10, who knows, living in your living room while you're trying to carry out the daily tasks of your life and talking with your children and making plans about dinner. And can you imagine how offensive that would be and how problematic that would be to have the government's troops hanging out in your living room? It would be pretty awful. So it's no surprise that the framers, I think, objected to this and put this amendment into the Constitution.
So do you think that the Quartering Act of 1774, do you think that was the straw that broke the camel's back in the American Revolution? Was it that living with soldiers was just so noxious that it propelled the colonists over the edge into the revolution?
Well, there were a lot of straws that broke that camel's back, so it's hard to say which one. But I think one of the things that the colonists hated about it was that they were being subjected to a rule that didn't apply in England. And one of the things they revolted for, remember, was they thought they'd been deprived of what they called the rights of Englishmen. And this was just another example of the crown feeling free to do things in the colonies that it wouldn't do at home. And that sent a signal to the colonists that you're not as important. You're not full-blown citizens. We don't care about you as much, and you don't have the same rights. And I think that was what was intolerable about it.
So this seems like an amendment that has this very specific historical background. But how does this kind of play forward into the future? Was there any danger that there might be later quartering of soldiers after the framing of the Constitution?
Well, there was always the risk. That even in the independent United States, that the government might at some point require homeowners to put up soldiers. And in fact, there's some evidence that during the Civil War this happened. I think the evidence is a little foggy, but there's certainly a suggestion in the literature that the Union government required homeowners to put up Union troops. And so it could have been a problem. It's not something that has in fact turned into a huge issue over time, which might say something about how successful the Third Amendment has been in our history. But it was always a risk. I think it was never far from the minds of the framers, this possibility that the government might decide to put its soldiers into people's private homes.
I think at the time of the Revolution and when the framers were putting together the Constitution, they had a real fear of standing armies, right? They didn't want a standing army in the United States. In fact, there wasn't one in the United States at all, a professional army, until after the Civil War, I believe. And now we see a standing army, a very large standing army of the United States as being pretty normal. How do you think the Third Amendment shows how our ideas of standing armies have changed over time?
One historian said that our framers had an almost panic fear of standing armies. And that was based, again, on the history of the English Civil Wars in the 17th century, where standing armies, the tradition was the king would disarm people he didn't like and then use the army against them. And that was seen as very bad. Standing armies were seen as somebody who was loyal to who paid them, not to the country. I think our army has had a different trajectory. I mean, really, we didn't have a large standing army in the United States on a regular basis until after World War II. So I think we're just less afraid of it because our Army has been more professional. Maybe because we feel like the Army is more loyal to citizens than it is to who pays it. Or maybe because we've just lost perhaps a vital edge of paranoia that the framers had.
Has there ever been a Supreme Court case that ruled based on the Third Amendment?
There's a single...
I want to say something. I want to ask a question about that to Zach and to everyone in chat. Do you think now, with what's going on, would the Army actually stand with us? Would the military stand with us? Or would it go with the government? I want to see what everyone thinks. Yes, I'm getting the teacher cap back on for a moment. And hello to everybody that just came in. All right, got one for us. Because I want to see what everyone thinks. Because this is a question I want to ask because some people... All right. But that's the thing about it. I just want to see what everyone thinks with this.
Government because they are following the ⅏⅏⅏⑦
The question is, would the military today, because they've said in this piece that they think the military would actually stand with the people. The question is, would the military stand with the people, with us, or would it stand with the government? Zach thinks it would stand with the government. And with the purging of a lot of the patriots in the military, I honestly think they would actually stand with the government. That's my opinion. I'm not saying it because there is no right or wrong answer on this, but I want to see what people are thinking right now because of the things we're going through. And Zach, repeat what you said, so if someone didn't hear it, they would know.
Government because they are following the ⅏⅏⅏⑦.
Put Tom's thing up for a minute, please. All right, and this is Tom's opinion, and this is why I'm asking this. I want to believe the Army would stand with the people. I was told by a young active duty soldier a few months that the Army will follow orders. That was all he would say, follow orders. But we know there are people within the ranks that would tell them to go after us. Yes, disavowed. I am cammed up now. And Zach probably likes it a little easier because if I want to say something, he'll know what I'm about when I'm about to talk. But yeah. No, the governor does not control the military, but the National Guard is controlled by the governors. So that's the difference. So when he wouldn't actually tell you whose orders he would follow, I think he's pretty much saying he would follow the president's orders. That's just my opinion, but I could be wrong. But let's continue because I know this one's not all that long.
Federal Court of Appeals case called Blom against Kerry, where the Federal Court of Appeals applied the Third Amendment in a New York prison riot case where guards were pushed out of their barracks and National Guardsmen were put in. But the Supreme Court's never done it. But the Supreme Court has relied on the Third Amendment. In fact, one of the most famous cases of the second half of the 20th century from the Warren Court was Griswold against Connecticut. That was actually a case striking down laws against birth control,
which was one of the forerunners to Roe versus Wade. And in that case, the Supreme Court was trying to figure out if the Constitution encompassed a right to privacy. And Justice Douglas wrote this opinion, which said that there were kind of penumbras or emanations from a variety of the amendments in the Bill of Rights, the Fourth Amendment, the First Amendment, and importantly, the Third Amendment, that suggested that the Constitution does protect privacy rights to some degree. That was kind of the high point for the Third Amendment in Supreme Court history. And even in the cases that followed the Griswold decision, which found, for example, the right to an abortion, et cetera, the court did not rely on that Third Amendment penumbra theory. So it was one case, the Supreme Court cited the Third Amendment as being the source of a sort of enigmatic privacy right. Other than that, the Supreme Court has really not touched the Third Amendment ever.
So there's kind of a suggestion of the right to privacy that goes along with the Third Amendment and also perhaps the Fourth Amendment. Do you think that's the way that the Third Amendment is perhaps most relevant to us now?
Well, it could be. I mean, there's been some thought, there have been some law review articles and other speculation on this, that, for example, when the government installs spyware on your computer at home, that's the equivalent of quartering troops in your house because somebody is inside your house spying on you and breaking your privacy, sort of like having to have a soldier at home. No courts held that as far as I know, but it's not crazy. And there have been a few other cases more on point where people claim that when police SWAT teams took over their homes to look down on the neighbors and such, that was troop quartering, but courts so far have said that's not the same thing since they're not actually sleeping there.
One possibility is to say, hey, the Third Amendment really plays no role. The courts don't talk about it. Nobody really knows much about what it says. And so it's really not important. On the other hand, you could argue, and I suggest that this is probably a plausible argument, that in fact, the Third Amendment has done a lot. The fact that you don't see cases about quartering of troops may very well indicate how well the Third Amendment is serving it. So the Third Amendment just is quiet, but that's because it's doing its job so well, and that nobody comes and tries to quarter troops in anybody's houses, and if they did, they would immediately lose. So you could argue from that perspective that the Third Amendment is one of the most powerful and well-working amendments that we have in the Constitution. One thing that's interesting about constitutional history is that sometimes we see parts of the Constitution that have been dormant for a really long time all of a sudden pop up into consciousness, either because the courts have started reading them differently or because the facts of the world change, and so all of a sudden the amendment or other constitutional provision seems relevant. And that could potentially happen with the Third Amendment. And what I would cite here are two developments in the world. One is that we see these days the police becoming more militarized, and so it looks kind of like the police are soldiers in a way when they come all armed and with their in armored vehicles and such. And the second phenomenon is kind of the increased surveillance that we're seeing from the government into private phone conversations, private computer files, and things like that. And so it's possible that a court at some point might think that the government is violating, if not the letter, then the spirit of the Third Amendment by basically engaging in the 21st century version of quartering by monitoring people's communications within the home in a kind of militaristic way.
So we've learned that the Third Amendment prevents the government from quartering soldiers in the homes of American citizens. And that, in fact, it does such a good job, the Supreme Court has only made one decision using the Third Amendment as its primary basis. But the Third Amendment's implied guarantee of privacy in the home may come to be more important as we debate the limits of government surveillance of our computers. To learn more about the Third Amendment, visit the National Constitution Center's
And I'm going to say this now. I actually disagree with these people. Honestly, I think the surveillance wouldn't be the Third Amendment. I honestly think it's going to be the one we're about to do and talk about the Fourth Amendment. Because with the surveillance, if they don't get a search warrant, then I think that would be the illegal stuff. That's my opinion. But I think that would be a violation if they are hacking into our computers, and which we know they are, but we have to be able to prove it in court. But yeah, I think that would be a Fourth Amendment more than a third. But I'm not an actual expert on it, so what do you think? Is it a Third Amendment or Fourth Amendment with that one, Zach, about surveillance? Very true, Devil Dog. But this is why and I'm going to ask the chat this, especially like Devil Dog and Tom. Do you think if they're doing surveillance on us, like with a certain somebody said they were, would that be a Third or a Fourth Amendment in your opinion? I want to see what you guys think. I want to see it that way, though, Anarchy, but all right. But this is why I like having these discussions with people on here. Zach, you got some smart people in your chat. But I'm gonna give Zach some time, but you ready?
I actually believe that it goes deeper than the Fourth Amendment. It's actually President George Jr.'s fault with the Patriot Act.
Zach, you need to watch the stream that I just did. You need to watch that about that 3-hour stream. Because, and Zach, do you mind if I actually share that video in the chat? Because I just did a stream of a friend of mine, Mr. Greg Kelly, that was in here just a little bit ago in the chat. He did one on Facebook because his YouTube channel is actually taken down right now. But we watched, there's an Alex Jones, it's an Alex Jones video from Sunday, but he points out a lot of different things. But I'm gonna put it in the chat. And I think you guys would, because this with that stream goes hand in hand with what we're talking about right now, and especially the Patriot Act. But yeah, that is. So you ready for the Fourth Amendment? Does everybody in this know what the actual Fourth Amendment says of the United States? And this is why I'm saying that the surveillance would be a Fourth Amendment violation. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Because that is the Fourth Amendment. So when a cop does not, and they did. The British did do that, Jet. The British actually kept, because right before everything happened with the revolution, the British would keep troops over here to keep it from actually happening. So yes, a little bit of history with that one, but very smart people in your chat, Zach. I love them. Exactly. But the Second Amendment has been upheld, that the right of the people to keep and bear arms shall not be infringed. And I'm not going to get into that subject right now because I'm a little PO'd because of the thing that I was streaming yesterday. Just saying. Yes, I've been busy here lately. Zach, let's hit this one because this is a very important one.
Hey, this is Kim from Khan Academy, and today I'm talking with some experts about the Fourth Amendment. This is the Fourth Amendment of the Bill of Rights, and the Fourth Amendment deals with unreasonable search and seizure. So here's the official text of the amendment. It says, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." To learn more about the Fourth Amendment, I talked to two law professors who specialize in criminal law, Professor Tracy Mears of Yale University and Professor Oren Kerr of George Washington University. And he's a particular expert in criminal procedure and computer crime. Professor Kerr, can you tell us a little bit about what the Fourth Amendment is and why the framers were interested in protecting these rights in particular?
The Fourth Amendment is a ban on unreasonable searches and seizures by the government. It's something the framers were interested in because they wanted to limit the government's power. At the time of the framing, the English king had engaged in some pretty bad things that the framers wanted to stop, and one of those was raiding people's homes with what was called a general warrant. A general warrant was basically a warrant that said the police could go anywhere and look for anything without any limit.
I asked Professor Mears to explain a little bit more about general warrants. She's a professor at Yale Law School who specializes in criminal procedure and criminal law policy.
They were a general warrant allowing these officials to search people's homes, places, papers, the kinds of things that the Fourth Amendment lists, and ways that people thought was not okay. The Fourth Amendment was primarily concerned with a couple of things. One, a case involving seditious libel investigation. It's a case called Intick, and a warrant was issued authorizing intic, that's the subject of the warrant, his arrest and the seizure of all of his books and papers, so that he could be prosecuted for seditious libel. That case isn't as well known as the second case, which is called the writs of assistance case. And basically, the writs of assistance involved customs inspectors who were trying to crack down on smuggling that was affecting Boston's economy. So to aid in that task, inspectors used writs of assistance that were issued by the king and authorized the inspectors both to draft assistance, hence the name writs of assistance, and to search any place where smuggled goods might be concealed.
The framers wanted to put an end to that, and so they said no general warrants are allowed, and searches and seizures have to be reasonable. That really means is the government can't just stop anyone, arrest anyone, break into someone's house. There are limits as to what the government can do.
But what are those limits? What determines probable cause for a search? And what renders a search and seizure unreasonable?
Yeah, what counts as unreasonable is a really big question. There are different answers different courts have suggested, but the basic idea is that first, if the government has a valid warrant, a search or seizure is reasonable. If a judge has signed off and said, yeah, the government has probable cause to search this place for particular evidence, then the government can do that. And then the Supreme Court has laid out a bunch of what they call exceptions to the warrant requirement, which are also reasonable searches. So, for example, if a person consents to a search, that's reasonable. Or in the case of a car can be searched without a warrant based on probable cause. That's called the automobile exception. There are rules that govern when the police can stop somebody temporarily. When the government needs an arrest, they need probable cause. There are basically all sorts of rules that the Supreme Court has laid out in a bunch of different cases that say what counts as an unreasonable search or seizure. The Supreme Court has said that probable cause means a fair probability that evidence will be found in a particular place or that a particular person committed a crime. So fair probability is the language. Now that's not something the Supreme Court has said, that's not 50%. That doesn't mean it's more probable than not. It just means like there's pretty good reason to think that there's evidence to be in a particular place or that a particular person committed a crime. So it doesn't mean a hunch. It doesn't mean the officer just had the idea pop into his head, but it also doesn't mean that the officer's certain. There's just got to be a pretty good reason, but not certainty to think that that person committed the crime or there's evidence there.
But when I asked Professor Mears the same question, she wasn't convinced it was so easy to tell what counts as probable cause. So what counts as a true probable cause to issue a warrant upon? Sorry, we can just skip this instead.
Let's take a second. I mean, I taught this today. These aren't questions that you can just simply answer. No one can, actually. Literally, I taught today the fact that there is no real law on what probable cause is. It's inherently a factual determination.
So how does this work in practice? I asked Professor Kerr if it's the case that a police officer has to convince a judge that there's probable cause to issue a warrant.
Yeah, so it can come up in two ways. In some cases, the Supreme Court says that the police have to go to a judge first and get a warrant, and then they have to convince the judge that what they're about to do is based on probable cause. And then other cases come up when the government has searched first or arrested first, and then they come back with the evidence or come back with the person who was arrested, and then there's a hearing as to whether there was probable cause for the arrest that already occurred. So either way, the standard's the same. It's that fair probability idea, ultimately up to a judge whether the police were right or wrong in doing what they did.
Interesting. So there is a little bit of prior legwork involved in some cases. What happens in cases when it might be really important to get evidence saved?
I want to take a minute and actually talk about what Anarchy just said, what Wingnut just said, because he makes a great point. He makes a great point. Zach, show us for a sec and put his statement up there, his comment up, please. But he makes an excellent point with this. The government has given themselves legal authority and permission to lie. How can anyone trust anything that comes out of their mouths when they are legally allowed to lie? And the thing about it, what most people don't understand, legally they have. Members of Congress passed a law while we weren't watching that actually says you cannot sue a politician if they don't do what they promised they would do. You can't sue them. There is no recourse against a politician. But that's the thing about it. He brings up a great point. Legally, they can lie to us because a police officer, I'm going to use a police officer because we do support them. We don't support the corrupt ones, but we do support police officers. A police officer can, let's say I'm a police officer and I come up to Zach and say, you've been accused of raping someone, and he says he didn't do it. I can lie and say I got actual photographs of it happening, even though I don't, and there's nothing that can be done. Exactly, Anarchy. It is a very broad, because I want to ask everybody a lie detector test. And I don't want Tom and I don't want Devil Dog to answer this right now. A lie detector test. And Zach, I want you to answer this. See if you actually know. A lie detector test. Is it admissible in court? If you think it is, give me a thumbs up. If you think it's not, give me a thumbs down. You think it is? So yeah. It's not legal to be presented in a court of law, but and I know this for a fact, cops can't actually say they can use it to, yep, they have actually told them that it is legal in a courtroom to people that do not know. And I'm happy that people know this stuff. I'm happy there are people. Now that's a heck of a question. My point of view, don't believe any of it, research it. That's how I do it. I research almost everything that I come across. But yeah.
ᖴᖇᘿᘿᘍᑍ, it's because of Section 230, unfortunately.
Yeah. Because we cannot go after Facebook or Twitter or any of them because they are protected. Now that I did not know. Thank you, Devil. This is why I love this group. This is why I love this group. There are people, and I will say this now, there are people smarter in the chat than me, and I love that they give us this feedback. They let us know what we can actually do. Now that's good to know. Thank you, Devil Dog. That one I don't. How can a cop show up at your door saying you called them and you did not call, asking a lot of questions? Because Jen, if you say that you plead the fifth, and that you want a lawyer present while they're questioning you, they have to give you they have to stop questioning you. So next week we will get into the next week we are getting into the Fifth Amendment. So we will have, if you guys want to think of some questions for us, please write some questions down that you want to ask us, because maybe because we got Devil Dog, we got Tom, they're very smart. And Zach, can I ask you a question? And if they would do it, can we have Devil Dog and Tom come up with us next week and actually talk about the Fifth and Sixth Amendments? If they would do it, if they will do it, that I would love to have that. All right, let's get back.
There's a bomb threat.
So there are some rules that are allow searches or seizures without a warrant, under what they call exigent circumstances. That basically means there was an emergency, so the government had to act without a search warrant. And so if there's a ticking time bomb that they think is going to go off in a package, and they've got good reason to think there is this ticking time bomb in the package, they don't have to say, hey, we're going to go find a judge, because by the time they do that, the bomb might have gone off. They can search that package under this exigent circumstances idea. So that's an exception to the rules. Although beyond that, there's no difference between a serious case and a less serious case under the Fourth Amendment. They're kind of all serious cases. So the courts have to follow and the police have to follow the same rules in less serious and more serious cases.
Professor Mears gave me an example of what seemed like a less serious case, but it's still a really interesting example of what counts as an unreasonable search and seizure.
I'll give you one more case that I'm sure the high school students would love, and my students love it. It's a case where a person was sitting in a noodle shop in front of a window, eating a big bowl of noodles, clear soup with noodles. And a police officer walks by the person eating the noodles and notices something floating in the bowl of noodles. So he enters into the store where the person is eating the noodles. And the person is left temporarily the bowl of noodles to get a napkin or go to the bathroom or something, And the police officer approaches the bowl, picks up the person's spoon, and stirs the noodles to see if he can find anything. And some baggies of crack float to the top. Did the person have a reasonable expectation of privacy in their food?
In their soup?
In their soup.
How did they rule?
They ruled that the stirring was a search. So if it is a search, and i.e. that you have a subjective interest in privacy in your soup that society is prepared to recognize as reasonable, then the police officer would have to get a warrant before stirring the soup.
This raises the question, where do I have Fourth Amendment rights? Are some locations protected and not others?
The building block of the Fourth Amendment is really that you have Fourth Amendment rights in your home, in your pockets, in your packages, but you don't have Fourth Amendment rights outside. You don't have Fourth Amendment rights in what you're doing outside, or if the police want to walk on what they call open fields, public streets. That you don't have Fourth Amendment rights in that. So thinking about how the Fourth Amendment applies just in the physical world, if the police want to break into your home, they need a search warrant. If the police want to watch you walk down the street, they don't need anything. It's not a search or a seizure, so they can do anything they want just watching you. If they want to arrest you, they need probable cause to believe you've committed a crime. So those are really the building blocks of the Fourth Amendment that going back to 18th century technology. And then the big question becomes, all right, well, how do you update that to a modern world?
It's also the case that the Fourth Amendment applies to seizures. What police have to show before they arrest a person or temporarily stop them or, briefly pat their body on the outside of their body for weapons. All of those questions are Fourth Amendment questions, as are questions involving how much force police actually use to effect the arrest once we've decided that an arrest is legitimate. So, we haven't talked about any of those questions, but the Fourth Amendment governs all of that. And remember, the Fourth Amendment governs all of those topics in a context in which the framers' motivations for enacting the Fourth Amendment have absolutely nothing to do with most of those things I just mentioned.
But the Fourth Amendment also has implications that go beyond warrants and seizures. Professor Mears thinks that one of the biggest Fourth Amendment issues today is discretion.
Many people have thought much more about how the Fourth Amendment protects privacy than how the Fourth Amendment addresses discretion.
And by discretion, in this case, you mean what they get to decide to do on their own, right?
Exactly so. And one way to see the difference between those two things is to think about a metal detector in an airport. So long as everyone is required to go through the metal detector, there is no law enforcement discretion involved.
So this is kind of where the public safety aspect comes in. That if we're all subject to non-invasive procedures at the whim of police, it's a little different than if individuals are kind of plucked for that reason.
Right. That it's just pointing out that the targeting of people for invasions is a different problem than the invasion problem itself. Right. And so if all we ever do is think about privacy invasion without thinking about the discretion problem, then we're missing something important.
For Professor Kerr, however, the most important issue at stake today regarding the Fourth Amendment is how it will apply to electronic media.
Well, the big question, I think, is how the Fourth Amendment is going to apply to searches and seizures of computers, of emails, the internet, new technologies that we all use every day. We wake up in the morning and hop online or go on Twitter or whatever you use online. Lots and lots of communications online all around the world. And how does the Fourth Amendment apply to that is something that the courts are beginning to answer, but they've only started to answer. Some really, really hard questions of kind of translating that physical world concept of the Fourth Amendment to the world of computers that we live today.
So, as we've learned, the Fourth Amendment ensures that government authorities can't raid homes, pockets, or papers without a warrant issued by a judge, and then only if there's a probable cause to believe there's reason for a search. What's tricky is deciding what counts as probable cause, and whether it's discriminatory to select some people to search, but not others. And how do we translate the Fourth Amendment to a world where our papers are all digital? Should the police be permitted to search our cell phones, our browsing histories, our private social media profiles? You can learn more about the Fourth Amendment by checking out the National Constitution Center's Interactive Constitution and Khan Academy's resources.
So, Zach, Fourth Amendment. Sure, in your opinion, does the Fourth Amendment, do they need warrants to search your computers, your cell phones, and all that? What do you think? Do they need a search warrant to do that? Hey, Dakota. And yes, they do have to have a search warrant to get into your computers, cell phones, if you do not give them access to it. And this is what I'm going to say, because we are on the Third and Fourth Amendment. If a cop comes up to you and you're out on the street and says something, tell him that you're not speaking, that you want a lawyer. He can still, because, and can you bring Anarchy Wingnut's statement about Terry versus Ohio? And yes, Tom, you're right about that. Yes, the Terry is actually guaranteed, because when a mayor in New York City, Giuliani, did stop and frisk, actually that was unconstitutional, because Terry versus Ohio made it unconstitutional for a cop to actually do that. And that was back in 1968. But yes. Hey, Monty. But yes. Yep. So if you share stuff on Facebook, you got no expectation of privacy with it. Me and Zach right now, we don't have privacy because we're on YouTube. But yes. And let me find it. Anarchy is about the red flag laws, because I am going to get into that a little bit. That is an ultimate Fourth Amendment violation right there, because red flag laws are just stop and frisk on a larger issue. And Yankee, you're right. Google checks. Yeah, but you can also, when you get out of a browser on your computer or on your cell phone, you know what you're supposed to do? Zach, you want to tell them what they're actually supposed to do when they get off of get off the internet, when they're not searching stuff? What are you supposed to do? Or maybe someone in chat, maybe Tom or D-Dog would tell them, you're supposed to do something. But there still is a trace on your hard drive, but you're supposed to do something. Because
Clear your cache and browsing history.
exactly. Yankee said it too. He said, delete your history. That's what you're supposed to do. That way, Google, and on your cell phone. Just an FYI, because we can talk about this, because this would be Fourth Amendment. If you know where you're going, take your location on your cell phone, turn it completely off. But we got, Zach, there are a lot of smart people in this group. I will say that right now. But yeah, if you know where you're going, turn off the location, because that can be that too. Devil Dog is right about that. Never. Put Emma's up, please. Her comment. What is the ATF? The ATF is the ACO Tobacco Firearms and Explosives Agency of the United States government. They pretty much deal with our Second Amendment. They try to harass us because we do believe in keeping our Second Amendment. Just saying. That's what the ATF is. They're ATF is a convenience store. I love that. No problem. That's why we want to, that's why we're teaching about all of this stuff. We want people to know.
Angry, I actually love the community we have now because they want to learn and not cause drama.
Because, and I'm gonna say this now. There's a lot of people that I do know that are very knowledgeable in this stuff, and I'm happy I get to do this with you, brother, because I love the people in the audience. They are very smart people, and we are getting this country back one way or another, and because I know you're going to reach out to a couple of people for next week, because I would love to have these two. And Greg is a very knowledgeable man. Greg is. And Zach, you have any final? Because we went on. If no one else has any questions for us. Yeah. Anarchy's right about the ATF. I forgot all about that. Thank you, Wingnut. It's a very important document in this country. People need to know it. The Constitution, the Bill of Rights, the Declaration of Independence, all of that is very important. And Devil Dog, we understand. That's understandable. But hey, Lisa. But if no one else has any questions, I think that you're talking about the one in Texas. I can't. Might be Ruby Ridge. That might have been Ruby Ridge. I'm not sure. Yep. Double Dog, you're a wealth of knowledge. I will say that right now. But yeah, there's a lot of things that's happened over the years. Go ahead, Zach.
Hey family, thank you for coming tonight and learning more about the Constitution. We need to come together and learn knowledge because knowledge will conquer everything. I love you all so much and have a great night.
We need you now. We need you now. One day
Good night, everybody.